Hello, and thank you for joining us for the Society of Certified Senior Advisors educational webinar series. Today's topic is Top 5 Estate Tips You Can't Die Without, presented by Linda Sekely. Linda Sekely is a practicing estate and elder law attorney with 25 years of experience, and she's the managing partner of the law firm of Linda Sekely and Associates. She's a national speaker, frequent collegiate guest lecturer, past faculty member of Duquesne University, and a trainer for national conferences and professional associations. She's also hosted and produced her own weekly syndicated talk show, Exit Stage Right, which deals with estate legal documents, probate, and elder law. She's also the published author of 5 books on estate planning and asset protection. Will you please welcome Linda Sekely. Linda, I'm going to turn it over to you.
Okay, great. Hello, folks, again. Welcome to Top 5 Estate Tips You Cannot Die Without. I'm Linda Sekely, as Dennis introduced me, and thank you very much for that, Dennis. And today I'm going to take you on a little journey through the 5 tips I've found in my 25 years of practicing law in my state of Pennsylvania, but they are universal, that talk about those tips you wish you knew about before something happens. And you'll know what I mean as we go through them. The first one I want to talk about is power of attorney. And you can see by the slide it says address the fear and sign. The fear is resulting from those folks who feel I'm giving someone too much power. If I named him as a power of attorney with no holds barred, I'm giving too much power, and I will become a victim perhaps. So I want to go through today some of the more common ways that you can remove this fear, either as you do your power of attorney or as your senior client or customer investigates their power of attorney. The first one I want to talk about is limited access. Now, this is where, for example, Mom wants to give a power of attorney to John. John's not her son. John is her nephew, and Mom only wants John to help her through some specific road bumps. For example, medical. She wants to make sure that John can communicate with her doctor, can transfer records, etc. So she definitely wants John as her power of attorney medically, and then maybe she just wants John to be able to sign checks out of one account to keep her bills rolling, not access all of her financial holdings and legal holdings and matters. So that's a limited access power of attorney. Very popular for real estate closings, for example, just naming someone to go to a real estate closing for us and their job is done. So limited access. If you're not sure what a power of attorney is, I mentioned before we were having some volume problems, and I think it's worth mentioning one more time, that these are basic 5 top estate tips that we're going through today. I'm saving a sophisticated or more advanced estate planning course for the next webinar down the Yellow Brick Road with me. So limited access is the first one we want to talk about. Divided duties. Mom has 2 kids. She's got a son named John. She's got a daughter named Mary. And John is a great financial mind. Not that he's a PhD in finance, but he's an accountant, and he does well with numbers. But Mary is a registered nurse. So Mom sits in dilemma and says, who should I name? Should I name both of them to do everything when really Mary would be great in the medical area? Well, we can divide the duties, folks. The financial, the legal can go with John's handshake and hand signature. The medical can go with Mary's judgment. So we're splitting the duties to give the best person the most logical job, okay? Very popular with folks that have 2 children, don't want to leave one kid out. They can split the duties. I did a power of attorney once for a businessman who named 8 different individuals to accomplish 8 different goals that he could foresee if he was unable to meet those goals himself. So we can divide it as close as we have hairs. We can divide this divided duties. Expiration date. You know, if you have any customers, clients, or their children who have a military power of attorney, these were drafted with expiration dates on them for the most part. So we want to make sure that that hasn't expired and we are without a power of attorney. And as you know, a power of attorney is giving someone written authorization to step in my shoes if at that time I can't walk in them. Okay? So expiration date, usually there is none. But one way that you can cause some security in that customer, client's, or your mind is you can use one. For example, I'm going to authorize John to represent me at the real estate closing, and this authorization is going to expire the day after tomorrow because the closing is done tomorrow. So there's an expiration date. By far, one of the most popular ones is the springing power of attorney, and it is the way it sounds. It springs into action or springs into effectiveness only when something occurs first. And I know you can guess what that something is: incapacity. So the wording sounds something like this. If I become incapacitated as determined by my attending physician, then John shall serve as my power of attorney. We always want a back door when we leave a front door open. The back door would say, and if I then regain my capacity as determined by my attending physician, then John ceases to be my power of attorney. Springing power of attorney, very popular with widows, widowers who are naming a professional. They only want that professional, their accountant, their advisor, their attorney, to jump on the bandwagon whenever the incapacity is proven first and represent them. So very popular. Now, here's a tip that just came up since all of the nursing home planning, and I do about 50% of my week planning on the preservation of assets for folks with fears or consequences of skilled nursing. We want to make sure that in that power of attorney is language that says there is unlimited gifting in line with the estate plan. Those are the exact words we want to appear there. And therefore, any power of attorney that would be using the gifting authorization is having a consistency with the heirs of that individual. Not just their girlfriend or boyfriend or their creditors, but the heirs already established under the estate plan. That unlimited gifting, the ability to transfer assets, is very important. Even though we are dealing with a 5-year look back for the nursing home, which we'll talk about a little bit more in a few minutes, we still want to be able to have that option available, a full transfer of the asset title. Okay? So we want to make sure that's in there. Check your power of attorney, check your moms, check your dads, check your clients or customers, see if that language appears. Always, 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 as in the Miss America pageant, where there is a winner named and a runner-up, so must it be in the power of attorney. We never want to name one person and call it a day. We want to name one person or people to do their job, and what happens if that first person is unable or unwilling to serve? We want to make sure there's a backup. Okay? So there's a little bit about power of attorney. Should you sign one? Yes. What is the age? The age of majority. In Pennsylvania, the age of majority is 18. So there's a hint for those grandchildren of your clients, customers, or yours that are off to college. Are they 18 years or older? They've got to have a power of attorney so that someone can access their medical files, cash their checks for them, stand in their shoes back home. Okay? Now, let's move on to something that everyone thinks they're an expert in, the deeding of real estate to loved ones. And I'll tell you, I'll tip my hand by saying this. In my 25 years of deeding real estate all over the country, and I've even done some foreign deeds, 85% of the time there is a better way to estate plan than transferring property by deed to your loved one as a gift, okay? And yes, if that deed says $1, that's a gift. It's not a sale, okay? So if mom's transferring to John for consideration of $1, it's a gift. It's not a sale, okay? Now let's talk a little bit about the deeding of real estate. You got to watch for that sinking ground. Absolutely. Here's some advantages, though. There's never any cake in the estate world without some ice cream on the side. In other words, there's something hot and something cold about everything. Advantages. Well, we're going to avoid state inheritance tax, death tax, if we're transferring the property away from mom and dad to their adult son or adult child, okay? But you have to watch. Most states, in fact, probably all of them, have a minimum amount of time that must elapse whenever you gift to that loved one before it's considered to be a gift in contemplation of death. I know, sounds ominous. This is how it works. Let's take Pennsylvania for an example, but you'll know the issues once you hear this. If you gift property and you don't live for a year from the date you signed that deed over, that property will remain 100% inheritance taxable when that inheritance tax return is filed for the individual, for the parent. Other states have different time limits. Pennsylvania is 1 year. Federally, it's 3 years. So there's a waiting period when you're gifting, especially large assets, you have to be cognizant of. It doesn't mean that somebody takes away that property. It just means that it's subject to inheritance tax as if it had never left the hands of the parent or that person who originally owned it. Probate avoidance, good news about this, it happens immediately. There is no waiting time to avoid the process of probate when you transfer the deed over to loved ones. Probate, which you probably know, quick refresher, is that procedure where you hire the probate lawyer, you swear in as the executor under a will, and you are journeying through the road of the court system until finally you can distribute the assets to the loved ones, heirs, and charities named in that will. We can avoid that process when an asset's not in the name of the deceased, and that occurs immediately. There is no waiting period for that to happen. But we have the two-headed monster of 5-year nursing home countdown raising its head. There was a transition relatively recently where it used to be a 3-year countdown or a look back. Now we consider it to be a 5-year look back as those rules are transitioning, if not fully transitioned by today. That means if I transfer my property to my son and 3 years later I have to go into a skilled nursing facility, then that transfer is held against me when it comes time for me to try to apply for Medicaid assistance from the state to help pay my skilled nursing home bill. Okay? There are some great ways to get around this when it comes to real estate, and I want to share a advanced technique with you right now just to show you the world out there when it comes to alternatives. It's not all one game, which is transfer the real estate for a buck or as a gift and be done with it. One example is transferring the real estate in exchange for the providing of caregiving services by that adult child to their parent. This is where we're transferring it from a gift to payment. Not a gift, but payment. You have to have that in writing. You have to have a personal caregiving agreement drafted so that it's not assumed by the state to be a gift. But you can see how powerful this planning technique can be. I just did one last week where the daughter was caring for her father. 24-hour care. He was living with her. He had real estate other than where he was living, which was with his daughter. We transferred the real estate to the daughter in consideration for the fact that she was caring for him 24 hours for a long time. Okay? And so when he fills out his Medicaid application, he can truthfully say he doesn't own real estate and it wasn't a gift. So it's very powerful. Just email me if you have any questions concerning that, but it has become one of the premier planning issues in estate planning when it comes to real estate planning. Disadvantages, here they come. In most states, I know in Pennsylvania, when you have two people on a deed, here we go. Let's say you say to me, okay, Linda, I believe what you're saying, so I'll only add my son to the deed. I won't give it all to him. I'll just add him to the deed, okay? So that I won't experience these disadvantages because I'm still on the deed, even if I'm on for part. Here's the trick. Creditors can reach the entire property because you are considered to be partners in this real estate. So, Mom transfers the deed to Mom and John, her son. John goes through a divorce, is in a car accident and is sued, has a creditor problem, goes through bankruptcy, owes support claims, anything that causes a problem or a flashlight to shine on John's assets, that light will shed onto that real estate too. And that's not worth that risk in today's litigious society. And you know what I mean. Okay. Now, if Mom and John are on the deed together, Mom has lost sole control of that property. So John has a voice and has the ability to act in renting it, selling it, stopping it from being sold, ousting a tenant, doing something on the property that Mom would not approve of. He has gotten some control because of this. So we want to come up with a solution where we're not parting with any control, let alone 50%. This is a definite disadvantage of real estate transfer. Then we have the tax man. The tax man cometh, and the tax man says, if Mom transfers the property to John, John's on the property only, he's the son, John doesn't live in that house as his residence. Mom dies, and John goes to sell the house. He's going to get a pretty big mosquito bite from the tax bug because his gain will be measured by what did he sell that house for after Mom passed, and what was Mom's basis? In other words, what did she pay for that house back in 1965, and add in those additions, which would never be enough to cause this to be dramatic, and adding in like improvements and things like that. That's your measurement for capital gain tax to be applied on his tax return. So, in most cases, it would have been cheaper for John just to inherit it. Therefore, he pays his inheritance tax when Mom dies. When he later sells the house, he has paid the piper to get a step up in basis, which means his calculation when he sells it later would still be the amount he gets when he sells the property to the stranger, but minus the amount he paid inheritance tax on when Mom dies. Much smaller bite, okay? So capital gain tax, very important, can be avoided with proper planning. Now, here's a controversial part. Everybody makes a big deal, and rightly so, about those homestead exemptions, real estate rebate programs provided by the county or the state. This is how you save that from being jeopardized. Let's say Mom transfers her deed to John. Mom is still living in the house. She's alive, very much alive, but she's getting a notice that she's no longer qualified to get a homestead exemption or a property tax rebate because the records in the county indicate she's not on the deed anymore. This is what you do. It's called a little life lease. It is a page and a half long, not a life estate, a life lease that basically says Mom's still living in the house. She's responsible for paying the taxes in lieu of paying rent to John, who now owns the house. And so Mom is entitled to those programs as being the payer of the tax and expenses. And that's attached to the application, and the homestead exemption is restored. So very simply, that's how you do it. Okay? Now, so you can see disadvantages 85% of the time outweigh advantages when it comes to real estate. Okay, thicker than water, bloodline. I would probably say 95% of the clients that I see on a weekly basis want this. This is where we're saying that if I die, the money goes to my son. My son's deceased, so he can't get the money. It passes to his children, not his wife, not his creditors, not the in-laws, not his bankruptcy creditors. The term that we use in Latin is per stirpes. It's a concept in two words that means passing the asset by representation and bloodline. Okay? So if your will, your client's will, your customer's will, your mom's will, ends in the words, then to my children in equal shares, that has not gone all the way down the bloodline road. And most people want it too. So we want that bloodline concept. The other side advantage of this is, let's say that everything was going to John, the son, but he's deceased. So mom's estate now goes to her grandchildren, who happen to be 14 years old. You can't cash a check when you're 14. How do we handle it? Well, within the estate document, be it a will, be it a living trust, there's a small trust set up for minor children. And the trick is this. The trustee is not John's widow. The trustee is the other child of mom, the brother or sister of the deceased John, the brother. So you see, we're keeping the control over the money in the bloodline as well as the assets, okay? And that's important to do so. Age-based. This just means as we are planning for bloodline, we are able to weigh in on the age of that heir from beyond the grave. A couple different techniques. There is no age attached to the trust for little Sally. Little Sally, if she's under the age of 25, say, can't reach the money till she's 25, that's putting an age on that trust. We can instead say for life at the discretion of the trustee. This is done very commonly for grandchildren or children with a tendency towards substance abuse, creditor problems, etc. Okay? So age-based, just as it does end at some time. It also can be what's called graduated age-based, very popular. The kid has the money in his trust. That grandchild at 25 can ask for a third of it. At 30 can ask for another third. At 35, maybe the rest of it. But here's what I want to make sure you know. When it's age-based like that, the latest trend is that it goes through one final screen by the trustee, which means at 30, Sally may withdraw the remainder of her trust, may withdraw at the discretion, the final discretion of the trustee. So you see what we're doing? Passing the sand through one more screening before we come to the gem of Sally getting her trust, okay? Because we want to make sure we use those provisions that are available in all states to protect that money that's sitting in that bin for Sally from her creditors, divorce, bankruptcy, lawsuits, etc. And that's the golden ticket, okay? Voluntary trust, very quickly what this is, Sally reaches her age 35 and she's able to ask for her balance, but she decides instead, you know, I think I'm going to let it ride for a while because she has a rocky marriage or she was in a car accident. They're trying to settle out the claim. That asset base can continue to be sheltered by her voluntarily continuing that trust. Very powerful option to make sure that's in that trust. And remember, this trust can be either in a will or a living trust. It's just the section carved out that addresses an age issue for the heirs. Okay? Now, an interesting concept that has arisen is this whole animal called motivational term planning. If I give you some examples, you're going to get it right away. If Sally is married by age 35, she may request the rest of her balance. Okay? If Sally has attained a PhD by age 35, she may request the rest of her balance. If Sally is divorced from her current husband by age 35, yes, I've done that, then she can request her assets. And probably the most entertaining one was this one. A lady sat across from me about 2 months ago and said, I have a very serious concern. I have no children. I'm leaving everything to my niece and nephew, but I want a condition before they can get anything out of this trust. And I said, well, what is it? She said, they have to successfully complete a ballroom dancing course and score at least a C in that course. And then they can take money out of the trust. So to each his own. That's what I have to say there. Motivational term planning, an excellent way to, again, control from beyond the grave. Okay? Now, let's go to our next slide, which is the living trust. Is it for everyone? No. Is it for more people than you'd think? Yes, I think it is. Okay? Now, what is a living trust? It's just a way, a different way to pass our assets to our heirs that hopefully, if done correctly, shields that passing from the probate process, controls the extraneous activities that have to occur with that estate, like appraisal and inventory, thus saving some of those costs. In many circumstances can reduce death taxes, so there are some definite advantages to this. Probate nationally is 6 to 10% on average. What is probate? Is what I've already mentioned, the passing by will or no will, if you didn't do a will, of those assets. Okay? So we want to try to pare down or eliminate that 6 to 10% times the value of the probate assets, because the beneficiary of that reduction is our family. That's why. Probate takes nationally, on average, 1 to 2 years in time before you're able to, just 1 second, before you're able to finish that probate procedure. Multiple states. This is when it comes up the most. My example is myself. I have property in Pennsylvania and 2 timeshares in Florida. Now, if I have 2 timeshares in Florida, my home state is Pennsylvania, then what's going to happen when I pass away? I'm going to have ancillary jurisdiction, meaning probate, happening in 2 states. So that's good if I can avoid it, is it not? As well as the appearance that trustee would have to make in multiple states. We want to avoid that. We want to make sure that we're avoiding probate, and the living trust can do this in multiple states. So property out of state is an automatic red flag that perhaps probate avoidance is what we want to do for that individual. And this, again, has nothing to do with avoiding probate as an expense itself. It could just be that hassle that happens when there's multiple states involved. Incapacity just means if that individual who has signed the trust becomes incapacitated. We can avoid the guardianship proceedings by simply having the living trust switch the control from that individual to what's called their successor trustee. Okay? So if we can avoid that, that's wonderful. Privacy. The AARP is rather excited about this because we don't have full publicity of the assets of the estate, the heirs, their address, all very simply put in public record. Okay? So we avoid a lot of that publicity by controlling that through the living trust. The trust lives on, as we saw. It doesn't have to end. There's a long time before this trust would have to end. Nobody listening to my voice would be around to see that end. That's how long states generally allow you to keep that trust going. On the flip side, the trust can be done in 4 to 6 weeks when that individual dies, because we're not going through that whole process of probate, the 1 to 2 years, if we only have a will. Appraisals. We don't have to be as formal in the appraisal world when we're doing a living trust as we do in the world of the will So that's going to accomplish saving of the appraisal fees and that high value that they may set on the real estate, the jewelry, the guns, the tools. Anybody who collects anything is really going to be interested in avoiding appraisal on it. One of the most interesting collections that I knew of was a woman who said, I have an unusual collection that I inherited from my mother. I don't want it to be subject to appraisal or publicity. And I had to say, what is it? And she said, I have a series of 40 personally written and personally signed letters to my mother from Joan Crawford. I said, okay. So something about this business, there's never 2 days that are alike, that's for sure. All right, let's move on. So that, in essence, is the living trust. Is it for everyone? No, nothing is for everyone, but it's for more people than you might think, okay? I generally use as a milestone with my planning, do those people have 90,000 or more in assets that would normally go through probate, yes or no? If they own real estate, the answer is probably yes. So that's when you want to present them with that alternative. If anybody comes to you as an advisor of whatever your discipline is and asks, what do you think about the living trust? Don't make the mistake of saying, well, I don't think you have enough money to warrant doing a living trust, because then you're confusing it with the old days whenever the only reason you did a trust was saving federal estate tax. Those days are gone. Now you're doing it for those advantages that we just saw on the last screen. Okay, there is no doubt about it, and this is our last subject that I want to cover, but it's extremely important. There is no doubt about it that the most appreciative legal clients I ever have in my practice of law are the parents of special needs children, whether they're adult children or minor age children, once they learn that their current estate documents would have been disastrous if they would have stood and their heir was that special needs child, okay? It must be done. There's no compromise. There's a couple choices. Client or customer comes to you and says, I've got an heir who's collecting SSI. Little quick aside, when you're disabled, you've got two routes that we're talking about. Social Security disability, where it doesn't matter how much asset base you have, it's based on the fact of your medical condition of disability, versus SSI. SSI cares about your asset base. You have to limit it to about $2,500 to $2,800, and that's it, to qualify for the very extensive benefits of SSI, where they cover all of your medical, pay you the check each month, there's no co-pays, cover your prescriptions, etc., because based on assets, you are more of a welfare level of assets, okay? This is why millionaires can have an adult daughter who's on SSI, because that daughter's assets are based on her own assets, not her parents'. So it's very complicated as to the planning. For today's purpose, I just want you to know that whenever you hear anybody say, I've got a granddaughter with juvenile diabetes, I have a daughter who's bipolar, I have a son who's has leukemia, I have a son who's on disability. If they just say that word, it's enough to look at this issue. Because this is it. If that parent, let's say it's me, and John is my son, and John is on SSI, and when I die, my will says everything goes to my children, and John is one of my children, he's going to inherit more than $2,000. That's going to disqualify him from his SSI and make him self-insured for medical reasons. Do you see why this is such a dramatic and important area? Sure you do. These parents work very hard to have their child qualify for this, and if they're self-insured for medical reasons because of this problem, what's the probability of them being able to get insurance when they already have that disability? Okay? So you see what the circle is. So you don't allow it to get to that point. So, if you ever are in contact with any will for any person or any beneficiary designation that says, my children, or Sally, or somebody that they've named in the will or the beneficiary designation is an SSI recipient, it must be changed. This is how you do it. You have supplemental special needs trust language stuck into the will or into the living trust or into its own trust for those parents so that money can still be inherited and used by Sally even though she's on SSI, but it does not jeopardize her qualification for programs. Extremely important, okay? So that's the dangers. That's the supplemental special needs trust. The old way used to be disinheriting this child or saying, I give this child $1. Well, that's not good because that gives that child the right to be a direct heir, and that's not good. So we don't want to give that child $1. In fact, we don't want to give any heir $1. We want them either to be in a special trust situation or intentionally omitted with a sentence. Okay, we don't want $1. We don't want $100. We want intentionally omitted or special needs language if that's the situation. Okay, so the old way was disinheriting them, but parents weren't comfortable with that. Then came along the pike, I'll name the trustee as the beneficiary, just her name, and she'll know what to do with the money from this life insurance policy for Sally, etc. Well, that's not going to work too well either because what if that trustee has this money sitting in her account in just her name individually and she has a creditor problem, bankruptcy, etc. So the way to do it is put it in the protective trust. But we want to coordinate it with the beneficiaries, as I said. The most common mistake made in estate planning is the wrong beneficiaries. And you don't have to go to law school to know who are the beneficiaries. Do they make sense? Is somebody dead that was named? Is somebody on SSI? Is somebody a minor? Never, 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 never name a minor child as a direct beneficiary on anything. Okay? Very few times can you say never. I'm telling you now, never. Last week I went into court 3 times because minor children were named as beneficiaries on annuity, life insurance, and an IRA. I had to go through the court system in order to free that money to be named to a temporary guardian, etc., etc. You get the picture. So you never, ever do it. And, of course, that lifetime term means that those special needs trusts go on for a lifetime. They don't end at any age the way we've discussed before, okay? So that, as I said, is the most appreciative client. That could be your most appreciative senior customer or client when all you say to them is, I know that your son is on disability. I don't know whether it's disability or SSI, but I believe you need to have that checked out so that he doesn't lose the benefits if you should pass away and they're named. Okay? And finally, and then we're going to wrap it up, any further questions, you can call the 800 number Certified Senior Advisors, and they will pass along to you my email address or my phone number. Questions are welcome. We couldn't take them today because of the microphone issues, but you certainly are welcome to try it that way by going through CSA. Thank you so much for joining me in my maiden voyage of the webinar world, and I hope to come back with you sometime in the future with some different ideas or perhaps some sophisticated estate planning issues for those interested in those. Have a wonderful day, and thank you again.